so they might hop on and stuff. So.
Okay. Well, hello to everyone. If you're joining us, hopefully you're here for Into the Future, mental health support for families planning for the future. This is the first of a three-part webinar series where we will have professionals and family members providing insight and guidance for families who need assistance planning for the future of loved ones. We're going to start with introductions of the agencies who are presenting this series, and so I'll turn it over to you, Taylor, to introduce us to a little bit about NAMI, if that's okay.
Absolutely. Hi, everybody. My name is Taylor Walker, and I am the program coordinator for the National Alliance on Mental Illness, NAMI, Sarasota, and Manatee counties. For those of you who are not familiar with NAMI, we are the nation's largest grassroots mental health organization, and we do serve Sarasota and Manatee counties. So we are excited to be working with mental health community centers to bring this to you, and also our wonderful speakers, Matechik and Mary, who have a wonderful presentation lined up for you. So Pat is going to go ahead and give a little bit information on why we chose this topic, and then we'll go ahead and get started.
Thank you, Taylor. Pat Mahoney's my name. I'm the board chair for NAMI, Sarasota and Manatee counties. And we've been organising this webinar. In fact, it started out pre-COVID, so it was going to be an in-person presentation with MHCC. The reason being that having worked with families and having worked with people that are living with mental health conditions, we are very aware that one of families' major concerns is what is going to happen in the future, and to plan for that, the importance of planning for that. Also, people that live with mental health conditions, peers, that I've certainly spoken to are very, find a great sense of relief to know that there is a plan and that they've worked with their family and that there is a plan in place for the future. I know my 98-year-old mother involves every conversation that I have with her is about how I might take care of my brother when she's not here. So it is a really major preoccupation, and we all have a lot to learn. So thank you very much for joining us, and thank you to the contributors today. I'm really looking forward to it.
Thank you, Pat. I wanted to just talk real briefly about mental health community centers. In case you're not familiar with this organization, I'm the executive director here. NAMI is a close partner of ours. We work hand in hand on a lot of different initiatives working for individuals with mental health issues. We've done things such as we refer people to each other's programs as appropriate. We've shared staff members before. We collaborate on educational offerings and on programming for people with a mental health issue. So Taylor and I and Pat and I work closely together, and we work with all the staff of NAMI. At mental health community centers, we have 4 locations: Sarasota, Venice, Northport, and Arcadia. And these are community centers where people with a serious mental health issue can come in to get social support. So we have things like support groups, one-on-one activities. We have supported employment. If someone is wanting to get back to work and has a mental health issue, they can enroll in one of our specialized programs or simply come into our wellness center where we serve food and have support groups. So we have a very lively, fun atmosphere in each of our locations, and have a lot of neat things going on. And we'll give you our website address at the end in case you want to look for more services if you're not familiar. Normally I would say come by, but everything is a little strange with the pandemic right now. The best way to really experience it is probably to see it. So if you want to mask up and come in for a tour, we are open because of the situation with serious issues for people with mental health diagnosis right now. We have remained open for the majority of the pandemic and continued offering services. We just have had to be sort of careful about how we do that and social distancing and that kind of thing. So I'll give my contact information at the end if anyone's interested in learning more about our programs. Now we'll turn to the content, which is an introduction to guardianship. We've asked Mary Howard Winters and Matt Matechik to present for us today. I formerly came from the guardianship profession, so that's how I knew these two. I told them yesterday they were our experts, and they were pretty excited by that designation, but they definitely are. They're going to draw from their personal and professional experience, talk about how guardianship cases develop, how a guardian protects person and property of a vulnerable person, give us an overview to the legal process, to establish a guardianship, and then talk about the administration and the sort of practicalities of doing guardianship. I did want to introduce in a little more detail each of these two. Mary Howard Winters has now been a professional guardian with a concierge guardian for more than 6 years. She worked previously in the medical community, the military. She didn't mention this, but she sometimes also does comedy, so she's very funny. Get prepared for that. She is well known in the community for the integrity that she brings to the guardianship profession. If you ever need a guardianship cleaned up or, consultation on how to really apply the ethical standards to do something the right way, Mary is a known go-to for that. She also added in her bio, I didn't know this, but she's acquired 5 chickens since I was last at her house. Also has 2 dogs, 2 sons, and a husband, and lives in Sarasota. Grew up in Sarasota, actually. Mary also is currently the president of the local guardianship board, which is an association for professional guardianship. So we've had kicked off with 1 meeting under her presidency so far. Attorney Matt Matechik is owner and attorney at Matechik Law Firm in Sarasota. He specializes in guardianship, estate planning, probate, and elder law. Serves clients in Sarasota, Manatee, and Charlotte counties. He strives to make access to an attorney easy, which I promise he does. I know from experience, he's a very accessible attorney. He uses technology now with the current situation of the pandemic to be able to stay connected with his clients. He's chair of the Sarasota County Bar Association Elder Law Section and is a member in the Florida State Guardianship Association. The Florida Bar's Elder Law Section, Real Property, Probate, Trust Law Section, Solo and Small Firm Section, and the Young Lawyers Division. So he's very active in all the legal components of his profession. He is a graduate of Florida State University and University of Baltimore School of Law, has previous experience with national security and counterterrorism fields, making him also a really trusted go-to person for any type of ethical questions relating to guardianship. And I hold both of these two in very high regard, and I'm really grateful they were able to present as our experts today. I look forward to hearing this. Matt also, just to wrap up, lives in Sarasota with his wife, and they're at home during the course of the pandemic with 2 young daughters. So if you tuned in really early, got to hear everyone's dinner plans for how they're going to keep the families at bay while we get the content started of the presentation tonight. So again, thank you so much. I'm sorry we can't be in person and give you a really warm welcome and round of applause, but we're ready for you. So if you two want to take it away, I'll turn it over to Matt to begin.
And I also just wanted to mention, please feel free to utilize the question and answer portion in the bottom. We're going to have a couple different stopping points where we're going to go ahead and answer some of those questions. So make sure you put your questions in there and we'll make sure they get answered. To you, Matt.
Great, thank you. Thanks, Erin, for the great introduction, and thanks, Naomi, for having us here today. Really glad to be here to discuss what is an important topic, and I think one that should be discussed more in forums such as this before something gets to a crisis mode or an emergency. The knowledge is out there, let's take advantage of it and make everybody aware of really what a guardianship is and isn't, and how it might apply to your situation or that of a loved one. Like any good attorney, I do have to open up my portion of this seminar with a disclaimer. And that, of course, is that this is not intended to be legal advice. This is all just for general informational purposes. I am not your attorney. I am an attorney. But we welcome you to the seminar to learn. Just keep that in mind, though, that nothing in here should be relied on for legal advice. So again, thanks, Erin, for the introduction. The obvious place to start here, I think, is who is a guardian. And of course, it's Mary who's with us here today, but generally the concept of what is a legal guardian. And I think the best way to start thinking about this is think about how a parent has guardianship over their biological children. And what does that mean? That means that that parent is regulating really all of that child's activities, where they live, what happens with their money, where they go to school, where they visit, where they travel. Any decision the parent makes for the child because they're the guardian. The child is not able to make those decisions for themselves. And of course, in the United States, when we turn 18, we are legal adults, and our parents, by default, are no longer able to make those decisions for us. We have our rights to exercise on our own, and those rights cannot be taken away from us without some judicial intervention or something rather significant. And so a guardian is a unique field because this is a entity that steps in and serves as a guardian for this individual in much the same way that a parent might for a child. In many situations, this guardian is controlling where this person lives, who they see, what sort of access to medical care and funds. And I say the word controlling, and I suppose in a strict sense that's true. But there's a phrase I want you to keep in mind throughout this seminar, and that's best interests of the ward. Best interests of the ward. The ward is the person under a guardianship. And all of these different topics that we're going to be talking about today, these processes and these stories, everything comes back to that. What is in the best interest of the ward? All of this is designed to make sure that the ward is looked after in the best way possible for that particular individual, while allowing them to maintain as much, individual liberties and pursuits as possible as well. And so a guardian, again, is going to step in and exercise rights of what's called an incapacitated person. And we'll discuss who that is in just a moment. A guardian can be a professional, such as Mary. She's one of several professional guardians here in the area, but it doesn't have to be. A guardian can also be a qualified family member, and you do see this frequently, where either a mother, a father, a son, a daughter, aunt, uncle, somebody sees a need to provide a guardianship service to a loved one, and they're willing to step in and subject themselves to this process and the oversight to look after that person. So it can be a professional, or it could be a family member, or really any adult, as long as they're qualified and meet certain requirements laid out by the state of Florida. Mary, as Aaron mentioned, is a professional guardian. And so I'd like to turn it over to her to just tell us a little bit about what that means and how that might differ from a family guardian. And we're very happy to have her here today as well to address all of these issues from the reality. I think you'll get a lot of the legal sort of, I don't want to say boring because I think it's exciting, but the legal issues for me, and then Mary's going to tell you what really happened. So Mary, please take it away.
Thank you, Attorney Matechik. So, gosh, such a buildup that you all led for me here. So let me start off by saying that I first became aware of guardian and guardianship because of a family member that went into crisis. And when I say by crisis is the system of mental health is inherently flawed. It works great when it's great, but when there's enough nuances in it and you have legal documentation such as a durable power of attorney and a healthcare surrogate, and you have those documents in place, but for whatever reason, the circumstances in regards to mental health, those documents can only take you so far. So it was a recommendation by a medical professional of this family member that said, you need to go to the next step. You need to, seek legal counsel, guardianship. So I embarked on that path in order to essentially stop the turnover of the mental health cycle and the system under Baker Act, under Marchman Act, under, you know, everything that basically, you know, the self-hurting that was going on with an individual through no fault of their own other than their mental illness. So I started my journey as a guardian, as a family member guardian. And what opened my eyes to becoming a professional guardian was actually a recommendation by somebody in the community of guardianship. It was actually a judge who's now retired here in Sarasota County that said, you know, I don't know what you do for a living, but this is what you should do, because what I bring differently to the table and what I think guardianship as a whole is, the process of guardianship, the legalities of it, the business side of it is traumatic enough for the family members who are trying to absorb and help their loved one. And so the difference that when you have a guardian who is coming alongside the attorney to support the family and petitioning for, you know, this guardianship, is you really are looking for the person who is willing to step alongside with the family and become the best advocate that they possibly can for the best interest of that family member that is in crisis. And so having that type of responsibility and accountability, now that I'm a professional guardian and have been doing so for, like Aaron Norris said, over 6 years, I understand the purpose and the intent to keep family involved. I subscribe to the philosophy because I actually also am affiliated with APD. I used to work as a supported living coach also, so I'm well diverse in different types of the mental health community. But the philosophy of the circle of support, which a lot of individuals with mental health in our community that are not of, you know, geriatric age, and also one of my main philosophies is the not about me, not without me. And so when you have the process of guardianship, and then how does that apply to the day-to-day operation, the responsibility of the professional guardian or even the family member guardian who's willing to step up and do this, it is a great responsibility and honor to be able to allow another human being to step in and say, whatever is in the best interest of this ward is what is going to happen. So that's really what the guardianship, or who is a guardian to me, and I approach it from, because I have that firsthand experience as a family member guardian. You do have guardians that come from all different, you know, backgrounds, social workers, retired nurses and everything, but really the who is the guardian is the guardian is the one that has given the legal authority by the court system through the judicial procedure, that they are the legal authority to make the decisions. However, that is not an almighty wielding sword. So in a snippet there, what I do on the day-to-day, that is kind of the jumping off point of who a guardian is.
Yeah, and Mary emphasized there that this is a judicial process, and we'll certainly be getting into that. And that's one of the points that we want to make clear today is, you know, getting a guardian in place is not something as simple as, hey, I need so-and-so to sign over guardianship to me. That's not how it works. There is a very involved process to make sure, again, that this is in the best interest of the ward, and it's a court process, and we'll talk about that in some detail here today. But as Mary said, you know, a guardian is given authority by the court to exercise the rights of this ward in the best interests of the ward, and that's really what the bottom line here. Again, best interests of the ward. That's what this is all about. So, of course, that begs the question, who is this guardianship for? We've used this word a couple times now, a ward. A ward is somebody who is under a guardianship. And there's a couple different ways somebody could become a ward and become subject to a guardianship. The one that's, I think, most common and perhaps most applicable to our audience here today is when that ward is what's called incapacitated, and that's the legal term for it. It's not meant to be, offensive or anything like that. It's the language of the statute describes somebody as incapacitated, um, and suggests that that person might benefit from being a ward under a guardianship. And so, who is an incapacitated person, and how do we figure that out? And that's sort of the big question, and how we get to these guardianships. The Florida statutes don't actually tell us exactly what it means to be incapacitated, but they give us some clues about what it means to have capacity. If you have capacity, you're able to make certain decisions of your own free will and understand those decisions and the consequence of those decisions. Decisions like where you want to live, how you want to spend your money, who your friends are, who you're living with, all these sorts of decisions that a lot of us take for granted every day. An incapacitated person might not be able to comprehend these sorts of decisions, and they might not be able to make them in an informed way. And because of that, the incapacitated person could be subject to exploitation, or vulnerable to schemes, or who knows. Unfortunately, there's a lot of bad actors out there who could take advantage of an incapacitated person. And one thing I have to be clear about, and this is something I have to discuss with my clients frequently, is the difference between somebody lacking capacity and just making a bad decision. And I think that's critical, and especially as we see, maybe a family member going through some difficult situations. If we're talking about installing a guardianship for this person, we really have to ask ourselves, are they incapacitated? Do I really believe that they don't understand this decision, that they cannot comprehend the consequences, or develop a logical rationale behind it? Or are they just making a bad decision? Somebody making a bad decision does not mean that they're incapacitated. On the contrary, perhaps it shows that they have capacity, and they're exercising their rights as an American and their free will to make a decision that is arguably bad for them. So, I see a lot of situations which can be quite sad. Someone sees a loved one maybe making a bad decision about where to live, or who to live with, or how to spend their money. Perhaps there's some type of abuse or drugs or something going on. But if somebody is actively engaging in behaviors that are damaging to them, and they know what they're doing, that doesn't make them incapacitated. So that's just something to consider as we're talking about this, and you're thinking about maybe cases you've seen or have heard about. The court, in order to find somebody incapacitated, is really going to have to be convinced that they don't understand these decisions. And that's very, very different from somebody making a bad decision. And again, once the court has determined someone to be incapacitated, then they may be able to benefit from a guardianship. And that's when the guardian can step in and start serving this ward now. And Mary, you as the guardian, you have the hands-on experience working with this incapacitated person or this ward. Do you mind sharing a little bit about what that's like, how you keep them involved to the best of your ability and to the best of theirs?
Sure. So when I am formally appointed, which is when the judge judiciously has reviewed the examining committee reports, and so those are 3 individuals that have been pulled from the rotation of the courts that are sent out to interview the individual for levels of capacity. And so there's different tools and conversations, and those 3 reports go back to the judge. So I don't have privy to any of that information until I am actually appointed, which means that there was enough documented information and recommendation to need a guardian. Now, Attorney Matechik can touch base on the different levels of guardianship, but we're just going to speak in general, just guardianship as a whole. So how this translates between what is a formal judicious documentation and language to the realist in me. So let's say, for example, you have an aunt who, you know, used to work and kept her own home and was successful professional, and she retires, and a year after retiring, you go to visit her and she's eating takeout food, and she is, you know, shopping online, and you're concerned enough that you contacted an attorney, or you contacted me independently and said, oh, my aunt's crazy, she's not making the greatest decisions, you know, I'm really worried about her. That's not what an incapacitated person is. You know, the word crazy gets thrown out way too much. So let's just make sure we're very clear that sometimes there's behavior changes in life, that nuances that family members aren't familiar with or don't fully support. So speaking to the relative part of when somebody has been judiciously appointed incapacitated, and I am now the appointed guardian, the conclusion of incapacity has already been made. I wasn't involved in that, and the attorneys weren't. It was a medical finding by the examining committee, who filed their 3 reports. So I don't get to decide who's incapacitated, and I don't get to decide what level of capacity they are. I then, once I'm appointed, I then am able to review the reports to pick up any pertinent details or information that I need to know about to really support the individual. And I approach it, my philosophy that I said previously was not about me, not without me. And there is no level of incapacity, in my opinion, that I'm still not going to sit down with that individual and have a conversation about their medical, about their finances, about their social welfare, about their needs and their wants and their hopes for the future. That is not who I am as a guardian, and that's not who I am as a humanist. And I try and make sure, and I hope that my fellow guardians, that we're all trying to remember that we are trying to take a judicious proceeding that is for the best interest of that individual and apply it so that we can make the very best of their life, of their experiences, of their relationships, but to also make sure that we are advocating for them and protecting them from abuse, neglect, and exploitation. And so if you tie that all into, when you have a mental health, you know, mental illness, or you have a traumatic brain injury, or you have something that changes your life, you know, catastrophically, it is really important to remember that they had a full life before they ever became my ward, and they had a full life before I ever became their guardian. And so just the concept of guardianship is they are my ward. I am their guardian until they die or I die. So we are in it for the longevity of the guardianship, and really to make sure that this person is always advocated for, protected, and that the families, that they are living their best life within what we can provide and support, based on those recommendations by the medical community that sees them and what's best for them, you know, financially. So I do hear a lot. I will tell you, once I get court appointed on a case, I will hear from family members or neighbors to say, oh, well, you know, so-and-so, she was out walking in her yard naked while she was watering the garden. That doesn't mean you're crazy. I mean, that just means, you know, she wanted to water her garden, you know? So, you know, we just kind of have to keep that in mind, because this is a very serious, you are passing on the rights. You are giving court authority to another individual. And so just because a family member thinks there's some oddities going on, that this is something that is very serious, that needs to be treated with such. So again, just because you have creative aunts and uncles or family members or neighbors or friends doesn't mean you know, that they are incapacitated or that they need a guardian. So Matt, I think we're probably at a pause here. Should we open it up and see if the moderator has any questions at this point?
Yeah, let's do that. And, you know, the chat's open if you want to just be sending questions in throughout. We mentioned in the beginning, in case anybody missed it, that we're going to take a couple pauses here and try to address as many of the questions in chat as we can, you know, if we can. So yeah, put the questions in the chat, and you know, we'll try to answer them as best we can. Do we have any in there currently?
Awesome, Matt and Mary, thank you so much for that so far. We do have one question. The question is, what does the statutes look like for grandparents who are wanting to petition a court for guardianship over a said child, say of their own biological child, that is no longer able to care for themselves, but the said child was never removed from Child Protective Service? If you have a guardianship over a minor, do you have to repetition once they turn 18? And if you need to reread that, it is in the regular chat box.
Okay, great. Thanks. Yeah, and thanks for the question. You know, in a lot of these cases, too, we'll have very specific details. Like it sounds like this particular one might. So we'll answer these questions as best we can in a seminar. But if you're in a situation where you feel like you might want to talk to an attorney privately to discuss your private situation and get some legal advice, please reach out to one. So the statutes, as far as grandparents wanting to petition the court for guardianship, and I'll pause there. The statute, if we're talking about a guardianship for somebody over 18, actually says any adult person, and then you have to meet certain requirements. So it doesn't matter if you're a grandparent or a parent or a brother. Your status as a grandparent does not necessarily give you any more or less ability to petition for a guardian. It sounds like we might be talking about a minor child here, which I'll just be frank, that's really more of a family law issue, and I don't do a whole lot of guardianship of minors. And what we're talking about here today is guardianships for incapacitated persons who are over 18. And so to get to the other part of that question there, if you have guardianship over a minor, do you have to repetition once they turn 18? Anytime anybody turns 18, they are emancipated, generally speaking. And so without knowing further details about that case, I'd probably say yes, if it's appropriate. Remember, a guardianship, what we're talking about doing is keeping somebody from exercising their God-given rights as an American that they have when they're 18. So it shouldn't ever be an automatic reaction. Okay, you're 18, let me get a guardianship. There are certain types of guardianships. One's called a guardian advocacy, where if there's a minor child who has grown up with a developmental disability, when they hit 18, there's sort of a shorter process to get guardianship for them. I'm not sure that's what we're talking about here, though. So hopefully that was at least a little informative. A couple layers in that question there.
All right, we've got a couple more questions. I believe this one is going to be answered later. You guys can clarify that for me. What do you do first if you think a loved one needs guardianship? Approach a guardian or an attorney?
I'm sorry, could you say that one again?
What do you do first if you think a loved one needs guardianship? Would you approach a guardian or an attorney?
I think that's going to be up to an individual's comfort level. And Mary, if you want to speak to this more, I think if you're in that situation, what you're comfortable with, call that person, find either whether it's attorney or guardian or social worker, reach out to the person who you're comfortable with. I will say it's important to have an attorney that you work well with and you like, but if your family member is going to be under a guardianship, you are going to be probably working more closely with the actual guardian once the guardianship's established. So certainly you want to put some thought into that choice. Either I think would be appropriate based on the circumstance and your comfort level. Mary, what do you think?
I would agree with that. I think, though, it should be noted, especially with a developmental delay of a minor that then has grown and reached the age of 18, if there's an Access 1 diagnosis and there are parents that are involved, but as this individual, grows up and grows, that I think that that's something that if you need a successor guardian, that they should definitely interview guardians. They should have conversations with them. Because you really want to, it's a relationship. It really is. And you have to, it's not a kumbaya per se at the beginning, but you have to feel that they're going to listen to you and you're going to listen to them. Also, you know, and we're going to get to that in the next section, you know, of who signs the petition, and how that proceeding goes. So that question, the rest of that question of who to speak to first, you can speak to either, but really there is a process. So that person, you know, really, you know, needs to be informed. And again, you know, a guardian can provide information and also recommendations or suggestions of other alternatives or least restrictive options that they should explore with, you know, support of an attorney or a place like NAMI or MHCC. But really, it is all about communication to start off.
Awesome. Do you guys-
Yeah, and if I can just add to that as well. The Florida statutes do require a guardian to have an attorney, just because there's so much court oversight, and depending on the circumstances, you could actually end up in court quite a lot. And so you'll want to find a team that is going to work best for you if you find yourself in a situation where you are going to be a guardian. You're necessarily going to have to involve both an attorney and a guardian. Maybe you're the guardian, or maybe you're looking for another, but there will be two persons involved.
Awesome. Do you guys want to do one more, or do you want to move forward?
Yeah, we'll do one more if we got it.
All right. Everybody, don't worry if your questions don't get answered now. I'm keeping track of them, so we should have time at the end to get through all of the questions. The next question was, is it possible for capacity to be restored?
That is
yes,
a great
yes,
question.
and double yes. Yes. Let me just affirm from a professional guardian that I have so enjoyed petitioning on behalf of the individual and having capacity restored on 3 guardianship cases within the last 2 years. So let me just emphatically say that yes, however, Attorney Matechik will let you know that there are, you know, requirements you have to meet, you know, the proof of. So go ahead now, do your lawyerly thing, Attorney Matechik.
Yeah, and that's a great question, and it's an important one. The ward will always retain certain rights, and among them is the right to ask to be let out of this guardianship. And I want to emphasize ask, because the ward will have to go through court and convince a judge that their capacity is restored and therefore they no longer need this guardianship. And a judge is either going to agree or disagree. And so, yes, the ward can get out of the guardianship and have rights restored, but it's not something that they're going to be able to do on their own, or for that matter, even the guardian or a family member. If a third party sees, hey, this person really probably doesn't need a guardianship anymore, you know, they can't just make it happen. Like really everything else in this guardianship process, the court is involved. And so that ward actually is going to have to get a court order appointing a doctor to examine them. And that doctor would then file a report with the court. If it's admitted into evidence, the court's going to consider it, and the judge will make his ruling largely based on that. So, but it's an excellent question, and it's one that should always be, you know, kept in mind, because ultimately what we want to do and what the law requires of us really is that we impose the least restrictive alternative on this ward. And so the law prefers, and the legislature, when they drafted it, preferred that these wards maintain as many rights as they can. And if they don't need a guardianship, the law doesn't want them to have one. So yes, that's a very long yes answer. You can have your rights restored.
But it is an important one, because I do just want to say this final thing. You know, guardianship is not an absolute. It's not they have no rights and then they're out of guardianship. And I have been involved in 2 cases where it was complete and total guardianship, called plenary guardianship. However, time, that 4-letter word time, is beneficial when you are trying to regain different levels of guardianship back, whether it's limited, what, you know, and what that pertains to. The courts want to see time along with the other mechanisms that are in place. So proving that, you know, the least restrictive, you can restore back levels of independence and rights. However, it is time to stabilization, whatever the reoccurring issue is. But it definitely can happen. But again, it isn't just something willy-nilly, and you definitely want, this is where your relationship with your guardian, the family's relationship with the guardian, or the family member guardian's relationship with the lawyers, this is where relationship and communication really come in. So that was a really great question, because I think that's what, there's a lot of preconceived notions about guardianship.
Awesome. Thank you so much. And then I guess we can go ahead and continue with the content.
Okay.
Sure. So we've talked a little bit about who is a guardian and what they do. The guardian is a court-appointed individual or entity that exercises the rights of an incapacitated person, a ward, when that person is unable to do so themselves. We talked about who might find themselves under a guardianship. What is an incapacitated person? Or excuse me, who is an incapacitated person? Who is a ward? That's somebody who's not able to safely exercise these rights on their own. And so we know who these two individuals are now. It obviously begs the question, and we've mentioned the court so many times during this seminar already. Well, how do we get there? How does somebody become judicially determined to be incapacitated? And then how does a guardian get appointed over this person? And I'll emphasize again, it is a process. It's not a quick one, typically. And I think it can often be a lot more involved than folks realize at the outset. And so an attorney, if you're exploring guardianship, an attorney really should be, letting you know that this is not a simple matter. I can't tell you how many phone calls I get, something to the effect of, my mom, dad, son, daughter, whomever is having issues. I need to get power of attorney over them so that I can, whatever the situation is, remedy their financial deficits or move them out of a house, whatever. It doesn't work that way, unfortunately. And then we'll talk a little bit about why in a second. But what these folks are actually probably at, even though they don't realize it, is they need a guardianship. And a guardianship comes into play, like we discussed, if it looks like somebody may be incapacitated and they need some help. Typically, especially though in mental health cases, that person does not necessarily want to accept that help. And so we find ourselves in a situation where we almost have to compel them to accept this help. And how we do that is we actually have to go to court and we have to file. It's a lawsuit. That's what it is. There's going to be a court docket. There's going to be this person on one side of the V and the incapacitated person on the other. And so I want to talk about what that looks like and why it's significant and why we do it this way. So the first thing, who's involved? The first person is going to be a petitioner. A petitioner is really anybody who's bringing a request before the court. And if we're talking about guardianships, the petitioner is going to be the person asking the court to appoint a legal guardian over somebody else. Frequently, the petitioner is a family member. It's often maybe a social worker or a nurse, a concerned neighbor, a friend. It can really be just about anybody who has concern and recognizes in good faith that this person might need a guardian. And so the petitioner then typically will reach out to an attorney and say, okay, what do we do now? That attorney then is going to prepare a couple of documents for the court representing the petitioner's interest and representing the facts presented by the petitioner to the court to achieve there's actually two legal objectives that need to be achieved here. Number one is the petitioner, through their attorney, needs to prove that this person is, in fact, incapacitated. So that's the first thing. Prove by the legal standard is clear and convincing evidence for anybody who's interested in that, that this person is an incapacitated person. And then number two, that it's appropriate for a guardian to be appointed because of that. So we're proving two things: an incapacity and the appointment of a guardian. And so how we prove that is we go through this judicial process. And once the petitioner files this petition, it's going to say something, typically something along the lines of, this individual, who resides here, who's of this age, the petitioner, believe to be incapacitated because of these reasons. And the petitioner is going to, again, with their attorney, list out why they believe this person's incapacitated. And they'll cite, personal observations. And typically these can include observations of behaviors that might suggest a lack of capacity. It might include, reports of doctors or other medical professionals. It might include this proposed ward's own statements. Personal observations that, if admitted into evidence in court, could demonstrate this person's capacity. And so when the petitioner files this, the court's going to do two things. Number one, the court is actually going to appoint an attorney to represent this alleged incapacitated person. So that's the person where the petitioner is trying to get a guardianship for. The court's actually going to give them an attorney. And that attorney comes from a very short list of attorneys approved to represent alleged incapacitated persons. I happen to be on that list, so I'm familiar with working both sides of the aisle here. And that attorney has to represent that incapacitated person's interest. And so, and especially with mental health cases, once an individual learns they have an attorney, and mom or dad or an agency or somebody's trying to get guardianship over them, they get visited by this attorney, and all of a sudden they say, hey, I don't want this, I want to fight this. And that attorney is going to have an ethical obligation to represent that person's interest. And so this attorney is appointed because, again, we're talking about folks who were alleging lack capacity. And so by definition, they might not be able to understand the nature of this legal proceeding. And so they get an attorney to represent their interest and assist them with this process and make sure that, they're looked after. So that's the first thing. The court's going to appoint an attorney. The second thing, the court's going to appoint what's called an examining committee. And Mary alluded to this earlier. These are going to be three professionals appointed by the court, medical doctors, nurses, psychiatrists, psychologists. There's various folks who could serve in these roles, but again, it's a short list of approved folks. And the court's going to appoint these individuals and give them a court order and say, go out and visit with this alleged incapacitated person and write a report for the court describing whether you believe they have capacity or they lack capacity. And I want you to start already be thinking about this process and the intensity of it, because we've already involved two attorneys. One of them is basically randomly chosen and a stranger entering into the process. And then now we're talking about three professionals from medical professions or various other professions who are familiar with working with these mental health issues, who are going to perform an examination of this incapacitated person. And, it can be, in some cases, it's okay. The alleged incapacitated person, maybe they see a lot of doctors anyway. This is another doctor coming into their facility. They undergo the examination with little, drama or maybe even objection. In other cases, the alleged incapacitated person can get understandably rather upset because this is fairly invasive. And so, to bring it back to what Mary was talking about, just the humanity of this, we're dealing with people here. And this can be a frustrating process. And it can be frustrating too for the petitioner, because the petitioner, if they made this filing in good faith, they're just trying to get help for this person. And it seems kind of counterintuitive, right? Because they're going to court and they're bringing these legal papers against this individual they're trying to help. And it can seem a little counterintuitive, and it's frustrating for the petitioner at times to see this loved one fight back or go through this. But that's what the statute requires, and that's how we get this moving. So, alleged incapacitated person has an attorney, is visited by these examiners. If two of the examiners say that this person is fine, they have capacity, they're able to make decisions, the case has to be dismissed. That's right in the statute. That's the end of it. If at least two of them say they lack capacity, then the case can be allowed to move forward. And so now we have these 3 reports that have been written for the court. And the next step then is a court hearing. And it is a hearing. There is a judge, there is an attorney, there's another attorney, there's probably witnesses. And, it's at least before COVID-19, it's at the courthouse. And I'll discuss how we're doing these hearings now in a moment. But this is a judicial proceeding. It's a serious undertaking. And that's one thing I always try to make clear to my clients is, this is serious. Why is this so significant? Why are there so many hoops? It's because the intent of the statute is to make sure, again, best interests of the ward. What we're talking about doing here is taking somebody's rights and transferring them to a third party, to exercise those rights on their behalf and in their best interest. So we better be really sure that this is the right thing for this person. And so the court, or rather the statute, intentionally does not make this easy. It's supposed to be somewhat difficult to go through this process to get a guardianship. So we have this hearing. The petitioner's attorney will typically ask for these examining committee reports to be entered into evidence. Sometimes they are, sometimes they're not. The attorney for the alleged incapacitated person, perhaps by their client's wishes, is really fighting back on this. And there might have to be some back and forth in court as to whether these reports are going to get into evidence to begin with. Again, there might be witnesses. There might be eyewitnesses who have observed behaviors. There might be, bankers, doctors, realtors, other persons who could provide testimony. And the court's going to consider all of this and consider all of it within the rules of judicial procedure. And the petitioning attorney is trying to prove their case. So if these reports get into evidence and they indicate that this individual lacks capacity, and the judge sees that and the judge agrees that this person lacks capacity, the judge will make his first of 2 rulings, really, or his first of 2 orders. And it's called an order to determining incapacity. And what that says is that we've been through this judicial process. We've examined the evidence. All interested persons have had a chance to speak. And this judge agrees that this person lacks capacity. And he signs a piece of paper that says so. And the next thing the judge is going to do is examine, okay, who are we asking to be the guardian? Now we've established that this person is incapacitated and they need a guardian. So who is qualified to do that? And, there's certain qualifications that have to be met. A professional guardian obviously has met those qualifications already, and they've gone through extra training. They've acquired perhaps some extra bond to demonstrate to the court that they have the qualifications and the credibility and the financial backing to serve as guardian, but they have to meet these requirements too. A family member or a professional, you're going to have to fill out an application with the court, and it's going to go through your employment history, your residential history, to some extent your financial history, your criminal history, a number of different things that the court is going to be looking at to make sure that this guardian really is up to the task and is suitable to serve in this very significant role. So the court's going to examine that if everything checks out, if over any objections from the other attorney, or perhaps with the other attorney's consent, depending on the situation. The court will then sign another order appointing this proposed guardian as guardian, and that at that point, this guardian is now authorized to exercise the rights of this individual in their best interest. And so that's a kind of a brief overview. There's a couple other layers in here too. One thing that folks are always concerned with is, well, what about, is the family involved? Does the family know? And yes, the family is going to know at least. The statute requires that the next of kin be served notice of these proceedings. And, that ensures that if there's ever, say, a bad actor in the family who, might be twisting the story or otherwise not suited to be the guardian or just doesn't have the whole picture, other family members have an opportunity to weigh in. Maybe they themselves want to be the guardian. Maybe they have some new information, but the court wants to make sure that the whole family understands that this is happening and understands the significance of it. So those family members, those next of kin, are going to be served papers describing the petitions in the process. Another critical piece of this guardianship process is the court's going to examine lesser restrictive alternatives. And this would be what I would call, a defense to guardianship. And so we emphasized again a couple of times that the statutes want to make sure that this ward, this incapacitated person, that we don't put a guardian in place unless we have to, because it's so significant. And so the court's going to be looking, and the attorneys are going to be conducting fact-finding to look for these lesser restrictive alternatives. What are those? Anything that could meet the needs of this incapacitated person, this ward, without having to go all the way to a guardianship. Typically, this can include something like a durable power of attorney or a healthcare surrogate or a trust, depending on the circumstances, that the incapacitated person executed before they became incapacitated. And why the court prefers that is because those documents were executed when this person was of sound mind, and it's a clear expression of their wishes. And so we don't want to force a guardianship upon them if they've expressed alternative wishes. So if those documents exist and if they can sufficiently address the ward's needs, then that potentially could eliminate the need for a guardianship. And so that was a lot of information, and I hope we get some good questions about it that we can ask. One that I get asked frequently, and it's a good one, is, well, how long does this take? It sounds so involved. It is so involved, and the answer is it can take quite a long time. I don't usually like to give a timetable because, of course, every case is different, but weeks or months is typical, and especially now with circumstances arising from COVID-19, could take even longer. And so that begs the next natural question. Well, this person needs help now. I can't wait weeks for these doctors and these reports and these lawyers to do their thing. I need help. I need to get him help now, or I need to get her help now. And the statute allows a remedy for this, for something called an emergency temporary guardianship. And this is an additional petition that's filed, which basically says, look, we're asking to find incapacity and we're asking for an appointment of a guardian, but we can't wait for this whole process to happen because there's an imminent risk right now that this person's person or property could be harmed. And so the court, if there's enough evidence to show this imminent risk, and you have to prove that in court with evidence, the court will say, okay, we'll appoint a emergency temporary guardian to serve as guardian while we're going through this entire lengthy process. And so that can sometimes cover the gap there and prevent maybe some unfortunate outcomes from happening. So again, that was a lot of information, hopefully generated some good questions. Mary, if you want to just tell us a little bit about what your role is, if any, during this court process.
So lots of information given by Attorney Matechik. So how this walks out from a guardian's perspective is I like to talk to the family members or the proposed petitioner so that I can understand what the issues are and what this particular case might involve. And the reason I do that is because I have to be able to gauge that I can serve my current cases to the very best of my ability before accepting a new case. And so I'm not employed, professional guardians are not employed by the court system. We are not employed by the county. We are either sole practitioner guardians or we work for an agency. There are some agencies in our area. So that being said, we're not under an obligation to take any cases. And I am only going to speak to how I run my guardianship practice. So I like to have some conversations with the family members at the beginning of this process. I have no legal authority at this time. So I'm not going and requesting financials or medical or anything. I'm really just trying to understand from a social perspective, what are the concerns and the needs going on with this individual, so that I can decide if I'm willing to be submit an application to be appointed as the professional guardian of this case. So I am kind of just in the background at this time, because really my job, which I don't like that word, but for lack of a better word, job, does not start until that hearing, that final hearing of appointment, where a judge signs those orders, like Attorney Matechik said, and then those transfer into these other documents that are called my letters and orders. And so until a guardian has those documents in her hand or printed off of the docket, because of COVID, we're not in court right now, I don't have legal authority. And those documents are really what allow me to now affect positive change for the best interest of this individual. The application process is exactly like Attorney Matechik said. For each and every case, I have to submit an application. I also have to submit an oath. And yes, it is a piece of paper, and yes, I have to sign it with every case because it identifies the case and the individual, but I take that responsibility very seriously, because if you'll remember what I said previously, they are with me and I am with them once I'm appointed until they die or I die. I take that responsibility very, very seriously, that I am signing an oath to do my very best professionally to support this individual emotionally, socially, medically, and whatever is in the best interest of that individual. So I think that is something that should really be understood no matter what type of guardianship it is. Now, guardian ad litems and guardians, there's other, remember there are other types of guardianship, but, guardianship that we're talking about is the age of 18 and up. So, so at that time, really, I'm kind of just in the background until I've been appointed, until that final hearing date of the letters and orders. I don't have any legal authority, but to do my due diligence to make sure that I am a good fit for this family and for this individual while they are, while they're meeting with the attorney and deciding what, are we petitioning, is it need an emergency temporary guardianship, or are we just filing for, guardianship? I am just trying to just gauge whether I am able to serve my existing cases, and if I will be able to, support this individual going forward. So from a guardian's perspective, I'm just kind of hanging out until that final hearing, when I'm formally appointed. So I think also that there is a need for a little bit of information gathering at the front before you're legally appointed as the guardian, only because I have military affiliation experience. So if I ask if this individual, did they serve in the military? Did they have VA benefits? And the person says, oh, well, yeah, actually they did. Okay, great. So now I know I have that extra lane that I have to be aware of. So there is some minor details that I do ask, but nothing I need specific details of until I know, which is when I'm judiciously appointed. But that helps me set up what you can call it fact finding. I'm just trying to do my due diligence so that I make sure that once I have those letters and orders, that I am off to the races. I am ready to start serving this case and doing my very best to make the situation, whatever it is, the best for the individual.
If I may, a quick point of clarification there. The guardian, I suppose if it all goes well, the guardian will remain in place until they die or until the ward dies. But that, isn't automatic. There certainly are circumstances where maybe a guardian can be discharged for various reasons, or maybe the guardian wants to resign, and they can do that with the court order. So I think, if everything's going well, then, and that's what we want to happen, then that's what happens. But there are procedures in place that could, again, if it's in the best interest of the ward, replace a guardian or otherwise see a guardian out.
Absolutely. That is important too, because sometimes you get to conflicts down the road that you can't course correct, or the individual wants to move up out of state with a family member, and it's in the best interest of the ward to surrender the guardianship here in Florida. And that's right, that is a really good point. But I like to think in my head that I get to serve my people until I die or they die. So, and they can get rid of me at any time if they want, but hopefully they'll keep me around. So, all right. So it looks like we're on to what happens next after the guardian is appointed. Matt?
Yeah, and this will be mostly your sphere, but from a legal perspective, the guardian, as soon as they're appointed, they are on the clock to take care of some obligations that have been imposed on them by the court. Primarily, they relate to the property and, of course, the person. And I'll say, too, while I'm describing this and really much of this process, I'm really describing a situation where a guardian has been appointed over the ward's person and their property. That's not always the situation. We'll talk about that in a moment. But assuming that this guardian has been appointed to look after their person and their property, this is what's going to happen. Again, there's a clock that's going to start right then, 60 days. And that guardian has 60 days to complete two different documents. The first is called a verified inventory, and the second is called an initial plan. The inventory, as you might guess, relates to an inventorying of the ward's assets. And so this guardian has been charged by the court to go out and find out what assets are titled in this ward's name, what they're worth, how they're titled, any titling issues, and report back to the court with what they found. And Mary will tell you a little bit about the logistics, how that actually happens. The second document that this guardian is going to have to produce is called the initial plan of person. And this document describes, the guardian's plan for this person for the forthcoming years. And what does that mean? Where will the ward be living? Who are the ward's doctors? What's involved with the ward's social life? Anything related to the ward's personal well-being, personal life, living situation, that's going to be in this initial plan. And again, there's a clock on this. It's 60 days. unless it's extended by the court. And that's to put the pressure on the guardian. The court wants to know that they're doing what they're supposed to do. The court has just given them incredible responsibility. And so from now on, the court is always going to be looking over their shoulder, making sure really that they're doing everything that they need to be doing, and bringing it back to making sure that this is in the best interests of the ward. After those two pieces of paper have been filed, after the verified inventory and the initial plan have been filed and approved by the judge, then the ward's attorney, if you think back to the beginning of the process, the ward got an attorney. That attorney is discharged. And it's really critical to think why they're still on the case at this point. The guardian's been appointed, okay, but this again is oversight over that guardian. So that ward's attorney is going to be looking over those assets, looking over that plan, and making sure that his or her client's interests are best looked after in there. So how the guardian finds the information needed to complete these documents and make decisions related to what's in that initial plan, I'll let Mary speak to how that actually works in practice.
All right. So the 60-day calendar is I'm aware of that. All guardians are aware of that. But there's a whole lot of moving parts that have to work in tandem in order to bring those two final reports together. And really, that time is the due diligence of making sure that I do my thoroughness. So once I have been given access to the examining committee reports, which I review, and I use those to when I'm drafting the initial plan. However, I also then find out who the individual's previous primary physician was, any specialists they were involved with. And I also like to go through that previous medical information so that I can try and have a big picture, a very big picture about the individual and the life that they were leading. It also gives me some indications and some recommendations professionally. I am not an MD. I didn't go to medical school. My decision about where a ward should live, in my opinion, does not trump medical documentation. If a medical provider who has the credentials in the background states that this individual is not safe to remain in their own home, or this ward, needs X, Y, and Z supportive devices, or I don't get to trump that. I don't have that authority, because that would be negligent on my part to think that I know better than someone. However, with that being said, I also make sure that lines up with all of the other documentation from the other professionals in that field are recommending. So that's how I start to build the initial plan. If the individual lives in their own home, I have to then also evaluate from the initial plan perspective, is living in their own home going to be a long-term opportunity? Does it meet a short-term goal, a long-term? How do we keep them safe in there? How do they financially support, staying in their own home? So those are kind of that's the big picture of it. If we flip over to the verified inventory, the verified inventory is I am sending those letters and orders like we previously discussed. I'm sending them to obviously the medical team and previous that I find, but I also have to now send them to the financial institutions and Social Security. And so then I have to gather all of that information. And so for those that are here on this webinar, if you can think about the business side of your life, the business side, your house, your mortgage, your rent, your insurance, your car, bill paying, investments, retirement. If you think about all of that, just the business side that involves the numbers, that's what the inventory is looking at. And so if I have an individual who I am now appointed the guardian of, and let's say they don't have any family support, and there's just a neighbor that has seen that this person is in need, and I am going on an exploratory mission of trying to locate and find assets. And so within that first 60 days, I am also building my initial inventory for the courts. And so Again, that takes time, but that window is there, 60 days. And there is a very serious statement on the bottom of the initial plan and the initial inventory that I signed my name on, saying that what I'm putting on here is all that I know about, is all that is there, and I am attesting that these are the values of it. With the plan, there's a statement on there, and Attorney Matechik can verify the legalese on it. But it also is on there saying that, you know, the place that the individual currently lives, or the plan that has come into place now, is what is in the best interest for safety, for physical safety, for social well-being and benefit. And I have to sign that document. And then those two, the initial plan and the initial inventory, those are my jumping off. That's what the court's going to look at. And so if they agree and they find that it is full and it covers everything that should be for that individual, as I've documented it, they will sign the order, like Attorney Matechik said. However, every year on the anniversary of those letters and orders being issued, I now have to file my annual accounting, which means the numbers we ended with have to, all the debits and credits have to line up. And then also the plan, I have to reevaluate. I have to get a position statement. So every year annually, I have to submit court required reports to the court also. So that's part of the responsibility. So if you can, if for those that are paying attention to the webinar, if you think about everything that has to do personally with an individual, medical, social activities, independence, those things. So the business side of that, but then you have the numbers, the business side of life, all that takes care of life insurance, homeowners insurance, whatever there's out there. So those responsibilities, I now take on the responsibility, which I take seriously, because now I am the person that's having to be accountable to the court. And my utmost respect is because if I do something negligent, or I do something that's not in the best interest of the ward, I am the one that has to go in. I am the one that has to go in and answer to a judge and deal with that. So that's a great responsibility. So that's just kind of the snippet of those 60-day reports, both of those that are needed.
And of course, the theme of all of that was the court is really looking over your shoulder, often. And these initial reports, and then every year you're doing your reports. And we don't have really time to get into it today, but there's a number of actions that the guardian cannot do without a court order. And so the court is very much involved throughout. And again, to make sure that the guardian and the attorneys involved, everybody's acting in the best interest of the ward. And, that's often the reason why perhaps a family member decides to go with a professional guardian instead of taking on this burden themselves, because it is work, and you really have to open your entire process up to the courts for the court's inspection, and as appropriate, another attorney's inspection. And so a professional guardian is able to take that burden off of the family member and then shoulder it themselves, and they have the responsibility and they have the liability. So, like Mary was saying earlier, make sure that, same as if you're shopping for an attorney, that you shop around, find somebody you like and that you think is going to do a good job if you decide to go with a professional. We had a question moment.
Mm-hmm.
Yeah, so there are a couple more questions that we can go over. So one question was, does a guardian have permission from ward to get input or discuss ward situations with family?
That is that's a great question.
Do you want to take it, Mary? You want to take that one first?
Well, you take the legalese part, and then I'll jump on. So you go ahead.
All right, and could you read it one more time?
Yep, does a guardian have to get permission from ward to get input or discuss ward situation with family?
The guardian is required to consider the ward's wishes as much as they can. But it is important to remember that the authority to make a decision belongs to the guardian, not the ward. And so, yes, they will consider the ward's wishes, and they have to. But sometimes, those wishes might not align with the reality. Sometimes they do. So, do they consider the ward's wishes? Yes, but that decision-making authority belongs to the guardian and the guardian alone. Input from family, that can be a gray area. I would say they are not required to consider input from family. I think many guardians do. I think many guardians try as much as possible to keep well-intentioned family members acting in good faith, informed, and consider their input. But if there's ever a situation where, in the opinion of the guardian, that particular family member's involvement is not in the best interest of the ward, then that guardian can, exclude them in the process and exclude them from information. The family is not entitled to know everything that goes on in the guardianship, and certainly not entitled to make any decisions unless, of course, with everything else, there's a court order that says otherwise. And Mary, I know you could speak to how tricky that can be to navigate at times, I'm sure.
Yeah, it's I think you hit it well just by your reference to it is a very gray area because remember I didn't know this individual and that family member's relationship prior to knowing being involved as the guardian. So, I can operate on the assumption that family members and loved ones are just genuinely concerned. However, at the same time, I have to, just be aware that I am protecting the ward's, personal information, such as medical and financial, from those that it is not singularly beneficial to their relationship with that family member. And again, this is not a decision, at least in my case. I don't just decide that Aunt Susie, because she wants to know if, her sister, who's my ward, got a flu shot or not. That's not the information I'm talking about. I'm talking about, questions regarding life insurance policy or how much longer they think my sister Susie's going to live, or financial questions about, well, does she have a life insurance policy, and is my brother named the beneficiary or not? So there's the spectrum. It's a wide brush. It really is. We can paint it with a wide brush. With that being said, I don't make my own sole decisions about whether I go to the attorney who is representing me as the guardian and say, this is the details, this is what's going on, this is what's asked. I'm not quite clear why. I'm always looking for the opportunity to hear a different perspective about it, because if you'll remember, there is an attorney that represents me as the guardian throughout the whole guardianship, and so I really rely on that expertise, even though it is in a legalese fashion. The attorneys that I like to do business with and that I trust and respect, is they're going to provide with sound feedback for me. And so again, the family member is not entitled to, like Attorney Matechik said. However, I do believe in a circle of support philosophy that, having family members be aware of things medically, or, maybe there's some concerns about the individual still being able to stay in their home, and the family wants that individual to be able to stay in their home, but financially it's not possible. And so there might need to be a top service conversation about a financial situation of the ward, just so the family now understands the angle in which we're operating. But again, less is more to protect the information of the individual. Now, if I have an individual, a ward, who says, oh, you can tell my brothers and sisters everything, and yeah, you can share everything with them. Okay, and I'll document that. But again, I have to also make sure that the protection is there for not just a wide open book, because again, I don't know the previous relationship before, and what I don't know, but we just always want to make sure we're operating on what the best interest of the ward is, as the guardian. So yeah, it's a great question. And that does come up a lot. So, okay, Taylor, any
And
other ones? Oh, sorry.
And if I just may quickly add to that too, think back to the process. This is one of the reasons the court makes sure that the family, or rather the statutes try to make sure that the family's involved at the outset. So if you got something to say, come to court and say it, and you'll have an opportunity to be heard.
Awesome. Thanks, guys. We do have a couple more questions. The next question is the family member ultimately responsible for their adult child financially? Example, if their child racks up a ton of bills.
I don't know that's necessarily a guardianship question. And I don't know the specific circumstances, but generally, if someone's an adult and their accounts are titled in their own name, then only that individual would be responsible for those debts or funds.
Great. There's some of these that are more general that we could say for the end. There is one, is it possible to set up guardianship to go into effect in the future in case of incapacity of parent currently assuming complete care in the moment?
That is an excellent question, whoever asked it, and I'm so glad you did. The answer is yes, and it's really a great way to ensure that you or your loved one, or really you, because you would be the one signing these papers, will have a guardian if and when you need it, and that guardian will be who you want it to be. I got to backtrack it because I'm an attorney. I said ensure. Won't ensure it, but it will make it more probable. So there's an estate planning instrument, and we're going to talk about estate planning a little bit at the end, called a pre-need guardian. And an individual can basically sign a piece of paper that says, hey, if I'm ever in a situation where I need a guardian, if I'm adjudicated incapacitated, then I would like for this person or this professional guardianship agency to be my guardian. And that will get actually filed with the court. And so if years later, for whatever reason, somebody is bringing a guardianship suit, trying to get a guardianship for this person, once that's filed, the clerk's going to search and say, oh, wait a minute, 15 years ago, they filed a pre-need. Let's see if that person is ready, willing, and able to serve. So that's a very smart estate planning instrument to put in place, especially as we're hopefully living much longer these days. So very good question.
Awesome. Let me see. I think some of these are more general that we can save for the end. There was one, if you become guardian over someone over the age of 18, do they lose the rights to vote and make decisions for themselves in all areas?
That's another good question. The answer is no, not necessarily. There are certain rights, in fact, that can never be removed. And that's to be represented by an attorney, to have access to the court process, to receive an education, to be free from abuse and neglect, to be as independent as possible, receive services and rehabilitation and healthcare, and of course to be treated humanely. With regard to the right to vote, the right to vote can be taken away from an incapacitated person in that when they're determined to be incapacitated. However, that right cannot be transferred to the guardian. And so even if they lose that right to vote, it's not as if, the guardian can suddenly vote for them. That's a good thing, especially here in Florida. We'll raise your thin every year. So good question.
Awesome. I think the rest we can save for the end. They're more general, so we can continue.
Okay, great. And that's a great segue into our next section here, which is what powers does a guardian have? And I guess the short answer, and perhaps somewhat uninformative answer, is whatever powers the judge says they have. So whatever specific rights the judge has transferred from this incapacitated person to this guardian. And there are a number of them. And again, they fall into two categories: rights regarding the person, and then rights regarding the property. And so, as far as guardian of the person, the guardian of the person can exercise certain rights related to determining residence, determining, weighing in on healthcare procedures, determining medical, dental, surgical, mental health treatment, um, you know, visitation, social life, anything again related to that person's personal and daily life is going to potentially fall under the guardian of the person. And it's not everything, like we just talked about. And so, what powers then might a guardian have over a property? If they're guardian of the property, they can dictate what happens with that ward's real estate, their personal property, their bank accounts, their government benefits, perhaps sell stocks as appropriate. A lot of these things, though, a lot of them cannot happen without further court approval. And so here again, the court always wants to make sure we're in the best interest of the ward. And so a common one you see with guardian of the property is someone comes under a guardianship and perhaps maybe they're already living at a facility, for example, or a group home, but they own this house that's fallen into disrepair and they can't go back to live there anymore. And so the guardian of the property might, for example, want to sell that house so that the proceeds from that sale could go to this ward and the ward could use them and enjoy them. And so that's an example where the guardian has to go to court and say, Your Honor, can I sell this house? Here's why it's a good idea. Here's why it's a fair market value. And the judge is going to agree or disagree. So, the guardian of the person and guardian of the property, they're two separate spheres and actually going to be mentioned separately in the letters that the guardian gets. Importantly, a guardian does not automatically exercise all of the rights that a ward could potentially lose. Through those examining committee reports and the hearing, the judge is going to determine which rights this ward is incapable of exercising. And only those rights, which can be transferred to the guardian, will be transferred to the guardian. So if it's all of them, if it's all of the rights the guardian could possibly exercise, that guardian is called a plenary guardian of person and property. Oftentimes, the ward maintains the ability to make certain decisions, maybe related to determining their residence or determining their social life or managing their investments, whatever the situation may be. And then the court says, okay, we've looked at the evidence, we've heard testimony, we've determined this ward still has capacity to do these specific things. So we're not going to give those to the guardian. In that case, the guardian is called a limited guardian of person or a limited guardian of property. And of course, we use the term limited because they're limited. They can't do everything that a guardian might normally need to do. So there's very broad authority that can be transferred to the guardian, but only after the judge has determined that the ward is unable to exercise those rights themselves. And so there's, if anyone really wants to be bored and check out the Florida statutes, chapter 744 is going to list out specifically which rights can be transferred. So, Mary, anything to add on that?
Yeah, just a few things, just from the streets view of what you just said, because I think you give a really good top service about the legalese of it, but the street view of that is, the letters and orders tell the guardian what authority has been passed, what, like Attorney Matechik just said, whether it's plenary guardianship or it's limited. If it's limited, then it's going to be very specific on what type of limited guardianship it is. And so with that being said, if it's guardian of assets, and not person, that means that I'm not involved in any of the medical, I'm not involved in where they live. But if I'm guardian of assets, then that means that I need to make sure that the bills can be paid and that the medical bills are paid and that they can afford the things that they want to do and stuff. So that is the authority of that is what's important. Exercising my role as a guardian is multitude, and it's plenty, and it's every individual need is different. So it can be as in I go to doctor visits, medical appointments. I'll go in the room if the individual is comfortable with it. If they're not comfortable with it, then that is a conversation that I have with the medical staff there, that they're to communicate with me after the pertinent details that I need to know, such as the case notes or change in medications, or I express concerns if there's concerns about stability on medications or not. However, there's certain things that I can't do as a guardian. Speaking of medications, I can't force medication compliance with an individual. I can't force them to take their medication. I can't force them to go to, to talk to a mental health provider. I mean, I can provide the information. I can set up the appointments. I can do my very best to encourage and advocate and support. But there's certain things, just like I can't force them as the guardian to, if they want to go grocery shopping, and because they have the right to choose their own food, if they're at that level of capacity and they can do this with support. I can't take the Twizzlers out of the shopping cart. I can't take the peanut M&Ms out of the shopping cart. That's not my role, and that's not the right that I have. However, if they are a diabetic, you can be sure that as my role as guardian, we're bringing in a nutritionist, we're providing supports and encouragement, we're offering alternatives and suggestions to the staff, or if they have CNA care or companion care or whatever, so that to keep them in compliance with, let's say, diabetes or not. But again, the authority that happens with a guardian does not mean that as a guardian I can force anybody to do anything. We have free will. At the same time, though, the authority to protect from abuse, neglect, and exploitation, and from them harming themselves, is very, very serious and very, very important. And so that is the role as a guardian, is if there is an issue with medication compliance, that we are reaching out to the services in our community, like NAMI or MHCC, or mental health providers in the area, or alternatives, and that's the role that the guardian really needs to. And we're talking in a general sense. If you look at guardianship in relation to our veterans, our service members that have PTSD or traumatic brain injuries from explosion, you're looking at a whole other different set. And that is, again, it is an individual that had a full life before this guardianship even occurred. And so it is the responsibility that, the authority that is issued judiciously to me as the guardian, that I really bring it down to that humanist level of that individual, and whatever's best. And we just keep course correcting, until we get there. So that's my little shtick, and how that comes down to the street level.
And if I may make a plug for the organization at Mary, you're currently the president, or you will be, of the Florida State Guardian. You currently?
Yes.
Okay, so you
currently am. Yes.
The Florida State Guardianship Association. You could check it out at floridaguardians.com. And among a lot of great material on that website, there's a nice section that lists specifically what rights can be transferred from a ward, and which of those rights can be transferred to the guardian.
Well, and that website also, if you look for our local chapter, Gulf Coast, which is Sarasota and Manatee County, here's the thing that we can all do to help each other in this community, because we all live in the Gulf Coast together, right? It's a village. I don't know where the village is with COVID, but we're all just trying to figure it out. That FSGA Gulf Coast has a lot of resources. It has a lot of recommendations for help, referrals. I really encourage those that are on this webinar that if you're unsure of, the best thing again is communication. It does not hurt anything, and it doesn't cost anything to contact the FSGA Gulf Coast, because we just want to help. We wouldn't be in this line of work if we didn't want to help, and the resources that are out there would just really blow your mind. You know, and so that's yeah, thank you, Matt, for bringing that up.
Yeah, it's a great resource.
Thanks. All right, so it looks
So-
like, are we on to what's the next fun stuff? Are we going to talk about how can guardianship be avoided?
Yeah, and you know, as you're listening to this, if you're thinking, "Gosh, this is a very stressful process," then you got the message. That's good, because it is, and it's supposed to be, again, because this is such a significant legal undertaking, and we're talking about somebody's rights here. And so, ideally, if we can avoid having to go through this guardianship to best meet somebody's needs, then that's what's preferred. And that's actually what's preferred in the statute and what the court's going to prefer. And so the best way to do that, where possible, is establish, like we talked about earlier, a lesser restrictive alternative. And typically that can involve some basic estate planning. So if you put in place, for example, a healthcare surrogate document where you say, hey, if I am ever unable to make a medical decision, you know, I want this person, I authorize this person to make that decision for me. Similarly, a durable power of attorney says, you know, among other things, if I'm ever unable, if I'm incapacitated and financial decisions or property decisions need to be made on my behalf, I authorize this person or this agency to make those decisions for me. A trust sometimes can also provide a way to avoid a guardianship, because it means there's funds available that are going to be controlled by somebody else for the benefit of this person. And so why do these types of documents let us avoid guardianship? Because, again, like we talked about earlier, it's evidence of what this person wanted when they could exercise, using their free will, make decisions, informed decisions about what they want. And so the statute, the court wants to respect those wishes. And so if those documents exist, like we talked about earlier, they could be a defense to guardianship. You know, not always. Certainly there's sometimes where maybe a power of attorney exists, but due to either the person's involved or the circumstances, or maybe somebody's no longer with us, you know, that doesn't help anymore. But it's a good step. And so, you know, if you're maybe concerned about guardianship for your future, you know, just the best way to protect yourself is do some basic estate planning. Now, certainly, you know, there's situations where maybe the person who would come under a guardianship might never be in a position where they could undertake some estate planning, you know, and then it's a little more difficult. But if you're able to, it's a great way to avoid your loved ones having to later on petition the court to get a guardianship to help you out. And someone mentioned earlier a pre-need guardian, and that's another great one where you express, hey, if a guardian is ever needed, here's the person that I want it to be. And certainly the court would give that a great weight when considering a guardian. So these documents, this healthcare surrogate, you know, this power of attorney and the trust, they're reliable because they're going to let somebody else manage these affairs when this perhaps incapacitated person can't, but it's the person that they identified, the entity that they wanted. And so somebody like Mary perhaps, or you know, other folks around town are able to step in as professionals and serve as trustees, agents, surrogates, decision makers. And so if you can put these estate documents in place, that's going to be the easiest way to avoid a guardianship. Now, I have to caution, you know, the person executing these documents, the person signing them, the person choosing who they want to manage their affairs, that person has to be the one to call the attorney and has to say, I want this done, and I want you know, my agent to be this person. An attorney is not going to be able to help you, you know, if you call, sad as the circumstances might be, and say, hey, I need a power of attorney over my family member, friend, whomever. the person who's transferring any type of authority, that person has to be of sound mind. That person has to reach out to the attorney, and that person has to make these decisions and sign these documents. Mary, anything on that?
No, I think you touched on it really good. You know, the estate planning, estate planning is great. It's great when it works and it's all set up great. You know, when it doesn't, fully fall through, as I think we'll talk in a little bit. But let me just also say that professional guardians also work as care managers. Some do, some don't. And so sometimes those are individuals that can hold a role here. Let's say, a family member lives out of state and their parents retired here, and, mom and dad are having some issues, but they just need somebody with boots on the ground. They need somebody in the area. And so there's other roles and that is not a legal role, that's a relationship. But the other opportunity for roles are, as long as that individual reaches out to their attorney and initiates and wants to do some estate planning, is I can hold the position of being asked to be an agent, a surrogate, a healthcare surrogate, a durable power attorney, a trustee. I mean, those are roles that have legal authority. However, those can be revoked at any time, while guardianship, that cannot be revoked at any time. That is a judicial proceeding that involves lawyers on both sides of the table, which that gives that, the courts appoint an attorney to represent the ward. He should have every right to have somebody advocate. So just know that there's many pathways to try and forecast the best needs and legal documents in place. But again, none of us, we can't predict the future. So I think
Right.
you did, really good. And a pre-need is great. But I think when we get into this next little section where we're going to kind of talk about the real world stuff, how a pre-need sometimes it doesn't always walk out the way you want it to. So I'll let you take this over for kind of our next category or topic, Matt.
Well, I think we're actually down to 9 minutes left. Is that right, moderators? So, I think, Mary, if you're good, perhaps we open it up to questions and try to address as many as we can.
Okay.
Maybe
Where
share.
are we at with our time, moderators, and our questions? How are we sitting?
We're pretty good. There are, it looks like there's 5 questions.
Okay.
Some of them you could answer fairly quickly.
Okay.
So is there a certification or class for guardians? And then does professional guardian mean that you are open to do others than your family members?
Okay, so I'll clarify this. A family member guardian is a different process. There is an 8-hour course in Sarasota County that is provided that gives the overview of what guardianship is in the county. And Attorney Matechik, I believe, has taken a section to teach that portions of it. And so that's an 8-hour course that a family member who is willing to serve as a guardian can take. A professional guardian, which is what I am now, I have had to meet the requirements by the state, which is there is a course that is held in different parts of the state, different parts of the year. I have to take that first, and then I have to schedule and sit for a state exam, and I have to pass the state exam. Not only that, I have to be able to pass a level 2 background screening. I have to be able to obtain a bond on my own. So I can't have felonies. I can't have any, I can't have any elder abuse charges. My background has to be nice and clean. So there are some requirements on there. So being a professional guardian has many moving pieces, as well as then continuing education. So a family member guardian is typically related to the individual. And that's how so those are the 2 differences that start off. Not all professional guardians have ever worked as a family member guardian for their own family. But that's just happened how I got started into realize that there's such a need in guardianship as a whole. So Attorney Matechik, take the floor.
Yeah, I would just add, there's qualifications. You mentioned the background check and the bonding. A non-professional could be subject to those as well. And then I think the other piece of, not could be, will be, unless waived by the court. The other part of that question was, can a professional take on more cases? I think, yes, up to the professional, though. Anybody applying to be guardian is going to have to meet the qualifications. Hopefully that addressed that question.
Awesome. The next question is, what is the average cost to an employee and attorney for this process? What happens if the family does not have means to pay? Same question for a professional guardian. How much should one expect to pay?
The fees are going to, vary, obviously. Shop around for an attorney, find one that you like and whose fees you're comfortable with. I obviously can't speak specifically to what any attorney might charge for any given case, but shop around like anything else. Guardian fees and attorney fees are actually capped at a certain level by statute and by administrative order here in the counties. So that varies too. Price out various guardians. If you can't afford a guardian, if the family can't, there are resources available. There's something called the Office of the Public Guardian, and that's a program managed here in Sarasota by Lutheran Services Florida. And what it allows is a guardian to be appointed at really no cost to the family, the ward. That's going to include the attorneys, the guardian, everything. Typically, to qualify, the ward is going to have to be indigent, and there's usually a waiting list because there's a great need for this. So if you're in need of that situation, I would encourage you to look up Lutheran Services Florida and their public guardian program, or call the Florida 12th Circuit and ask about the public guardian program.
Mm-hmm.
Awesome. And I believe this is the last question, unless anybody else throws some in there. Do you have any experience with advanced psychiatric directives?
Probably, I'm just
pertaining
not.
to
yeah. It's a pretty general. I think it's a general question. I would say no, but I don't have a whole lot of information.
Yeah. So how about we circle back real quick, and we'll give a few more minutes for the questions to come in. Let's talk about I think, Matt, you and I can speak to real life cases per se, but in an abstract way, of course. But let's walk out. You spoke earlier about pre-need documents and estate planning. So what happens when you have somebody that comes in and they want to do estate planning and they want to do a pre-need, and she wants to put her sister down as her pre-need guardian? That's appropriate, right?
Could be, yeah.
Could be, right. And it could be. But what it also could be, let's say it is appropriate and she's on those documents, and let's say those documents exist for 15 or 20 years.
Mm-hmm.
And now we're at the point where the person who signed those documents now needs her pre-need guardian to move forward into that role. And her sister, who's 5 years older than her, is not faring well health-wise. So then what happens?
Yeah, the same court process. And so the court's going to give strong, certainly the court's going to examine that pre-need document and try to give it preference, but that person still has to be ready, willing, and able to serve and still meet all the same qualifications that anybody else named in the document. So a pre-need does not automatically mean that person will be named.
And not to cut you guys, sorry, Matt, not to cut you guys off really quick. I don't know if the webinar will shut off right at 6, but I'm going to go ahead and launch the poll before we lose some participants. So to all of our participants, if you could just answer the questions on the poll that should have just popped up on your screen, that would be very helpful for us, just capturing some data and just seeing how you liked this program.
Get it.
Erin, did it pop up for you guys as well?
It did. Looks like it popped up.
Okay, perfect.
Didn't let us vote for ourselves, though.
Yeah, I was just going to say, unfortunately, the hosts and panelists cannot vote for themselves. Yeah, so.
I don't know whether we'll cut off right at 6. I don't think we will, but I do want to thank both of our panelists, Matt and Mary, for their presentation. I think that was wonderful. We'll follow up with each of you if you have any, if we get any more questions or anything, we can always put people in touch with you. Taylor, did you have contact information that you were going to screen share or something?
Yeah, I do. And then I'll also send out, I'm going to send out the recording probably tomorrow or by Friday when I get it edited. And I'll also include the contact information in that as well.
Great.
Sounds good. I want to thank everyone for their attendance. Oh, good. That's switching over to show the next upcoming webinars. We do have part 2 and part 3 in the series still, and Taylor can get information out about those events, so hopefully everyone will register for those as well. I think we each have some upcoming events that we want to talk about too, but I think in the interest of time, Taylor, we may have to have you add additional events maybe to the email that you send out for the participants here today. And then is there anything else?
I don't think so. I think that is it. So here's information for NAMI. And then we also have mental health community centers. And then there will also include contact information for Matt and also Mary. So I will send that out to all the participants later in the week.
Good, thank you. Thanks to everyone for their participation. It was a really good way to kick off the series. So we appreciate your presentation, and all the questions were great as well. So thanks, everyone. Have a good evening.
Thanks.
Thanks for having us.
Thank you.
It's a
All right,
pleasure.
bye-bye.
Thank you.